okay, when he stands up and yells and screams. Okay, we're trying to make you think rather than yell at you at this point. Okay, and yeah, I agree. I think that he would have been much more difficult.
Now, in defense of the court, the judge really has to take himself out of the liability picture, and he's going to shift the liability over to the prosecution, and that's what I did. But you know, judges aren't always the way you think they are. If a fella comes in there and presents himself properly to the court and wins the sympathy of the court, then there's a chance that things will go his way, and the judge will take his side. And this whole issue on affidavits started in a case that I had in California in 1973, where I put an affidavit before the court claiming that money was exempt from tax seizure as a tool of trade. And that was substantiated by the state administrative code. I gave that affidavit to the marshal of a municipal court, and in the affidavit stated that not only was money a tool of trade, but that I was an artisan engaged in commerce, and that money was a tool of my trade. And furthermore, that the Bank of America had entered into a conspiracy with the state of California in depriving me of my rights to due process. Stated all of this in the affidavit. So the burden shifted to the state of California to overturn that affidavit. They brought suit against me in the Superior Court of California at Stockton, California. This is the beginning of Proposition 13, is what it was. And so Evel Younger, the Attorney General of California, appeared with 10 attorneys to overturn this affidavit. And they weren't able to do that. The judge took my side in the case because I did not make appearance in the court. I stood at the back of the court, spoke to the judge that I was an interested party, and that I wasn't granting any jurisdiction to the court because the affidavit spoke for itself.
So you didn't cross the bar?
So I didn't cross the bar. The affidavit spoke for itself, and it was the duty and the responsibility of the state to attempt to overturn that affidavit. The judge turned to the Attorney General and he said, "Mr. Younger, you have 30 minutes to put on your case in an attempt to overturn this affidavit. This man's properly pled his rights not to participate in this matter. The affidavit does speak for itself, and the court will have to act as his proctor in the matter." So the Evel Younger assigned the speaking task to a Japanese gentleman, can't recall his name right now, who stood before the court and argued that money couldn't be a tool of trade because tools of trade had intrinsic value, that you had to go to a hardware store to buy them. It would be something like a wrench or a screwdriver or a hammer, something like that. And that consequently, because tool of trade had intrinsic value, money couldn't be a tool of trade because money itself was a memorandum of debt of the Federal Reserve Corporation, or pardon me, of the United States to the Federal Reserve Corporation, had no intrinsic value, so it couldn't be a tool of trade. That was their argument.
That was the government's argument.
So the judge said to the government attorneys, he said, "Well, I've researched this affidavit." Well, of course, they had argued that the affidavit didn't have any merit and should be dismissed because it didn't have merit. They'd maintained that they had researched the law in the 50 states as far back as history permitted, and that they hadn't found a single case where money had ever been argued to be a tool of trade. This was the first time it had ever been brought before a court, and consequently the argument was frivolous because there was nothing to uphold the argument. The cases had never been heard.
Just because there was no prior law?
Right, and so, you know, public policy, you know, in that particular case said that the government's position should prevail. So the judge said, "Well, I'll give the state of California 30 days to respond." I'm just trying to show you how a judge could kind of...
He's favored.
Well, he had read the affidavit. He thought it had merit. They said it didn't, and he argued for me.
But he was giving every chance to them.
He gave every chance. He gave them 30 days to go back and file a brief. Then he stood up and he pointed to me in the back of the room and he said, "Sir, I'd like to meet you in the hallway outside the courtroom after I've removed my judicial robes. And if you would wait for me out there, I'd appreciate it very much because I'd like to speak to you." He went into his chambers, took off his robes, came back out into the hall, introduced himself, a very fine gentleman. Took me down to the law library in the lower floors of the courthouse, introduced me to the law librarian, and arranged for me to have a key to that law library so I could prepare a brief in response to their brief when they filed it. He even showed me a roll of books that he had researched. And of course, he told the state attorneys that he had researched the affidavit and that he was tending to believe that it had merit and that their arguments weren't strong enough in their oral presentations to overturn the affidavit. That's why he gave them the 30 days to prepare the brief.
Well, I think what I just heard you say was that in open court he gave the opposition every time chance he could.
Sure.
But he was still an individual, he was still a human being, and he not only thought that your affidavit had merit,
well, he had a courtroom.
But he also had respect for you as an individual.
Yes, he did. And there were a courtroom of reporters there. So, so what happened was they weren't successful in overturning the affidavit because in my response to their brief, I stated that Abraham Lincoln stated that a lawyer's knowledge of his stock and trade and that he should value it accordingly. It became apparent to me, and explained in my brief, that if an attorney establishes the value of his intangible knowledge, then he's given it intrinsic value. That it's the person that holds the property that gives it intrinsic value. The seller gives it intrinsic value. The buyer gives it market value. Yeah. There's a difference.
Yeah, it has no real value until
yeah,
there's a buyer.
So this is the way I rebutted their argument in my response. About 2 months went by. I went down to my store. I had a liquor store in Lodi, California at that time. And I went down to my store and there was a stack of newspapers there. The top page of the Sacramento Union normally would say Sacramento Union at the top of the paper, and that day in the center of the paper it said Sacramento Union, and the headline at the top said, "Court slaps state's hands for illegal cash grab." They ordered my money returned. So it shows you how friendly a judge can be.
Thank you.
Okay. What you saw on the court and the exchanges there is only going to get better. Keep in mind that this was the first time we attempted any of this. Okay? As the people that we are in contact with around the country report in, as our buddy in New Jersey did today, I mean, isn't it great that he goes to court and when he actually called during the recess and says, "What do I do now?" Okay, and then as soon as he's done, he calls in. And so we not only get an up-to-the-minute report and the results, but we get to hear almost verbatim what was said. And as we get into this program with this court process that we're doing, we'll have the actual transcripts so that you can listen to what the exchanges actually were like between Judge Tanner and Dan Benham up here. And so we'll be able to really actually give you the actual feedback. And you'll get to become accustomed to the actual verbiages and the tense and all that they use. Now, as we develop a catalog of those things, we'll put together packages that will be able to call up or email and say, "I've got this situation coming up. Can you send me a videotape from the court of how I should do, what I should do?" And you can watch it, and you can watch the responses and watch the critiques. What an asset that will be. Okay? So what we're trying to do here is build a nationwide legal team. Okay? That really can help you in just about any circumstance that you come into or that comes your way, and that you can tell your friends about or whatever. Okay? Now, obviously, that's going to take money, and we still haven't worked that out, but we're working on that, and we'll try and be as good as we can be. Several of you have documents and packages and other products or things that you're using from other people. All I'm going to tell you is you better know what you're doing, whether you use my method or our method or this guy over here's method or that guy over there's method. Don't do anything you don't understand. Okay? It's better to go in and ask for a continuance, take another 15 to 20 or 30 days and learn a little bit more. Spend a little more time on the phone. Get comfortable. Associate with people in your area that think like you do and build a support team there. There are people that we know that when they go to court, they fill the courtroom.